So you're welcome back to this part two of the review of the Free Zone Acts, and we're going to continue from where we ended. In the part one, we'll look at how the Free Zones Board is established. We looked at their functions, and then the tenure of the members of the board, their meetings, and the use of committees. In part two, we are going to look at the establishment of the free zones itself, how free zone developers can apply for license to develop a particular area, and then also how free zones enterprises can get a license to operate when we look at from section 11 going. So in under section 7 we continue on, and it says declaration of a free zone. It's subject to the Constitution and any other enactment in force relating to the acquisition of property. The President may, on the recommendation of the board, by notice published in the Commercial and Industrial Bulletin, declare any area of land or building as a free zone, any port, any airport, river port, seaport, or lake port as a free port. Now, this is how it works. We explained that the free zone enclave is an area that has been declared by the free zone board as relating to an area which is outside the customs territories. In other words, customs rules and regulations are relaxed over there. Those of you who know Tema from TT Brothers, going to that stretch that spans across that place to Pombaria, or Pombaria. That whole stretch is where we currently have the majority of the free zone enterprises operating from. So the rules are that the president may declare that area as a free zone, and because it is a free zone, it's more like a government acquired property, and normally that is done in conjunction with what the Constitution says regarding the acquisition of property for government or for a national purpose. So section 7 is saying that before a place can be declared as a free zone, the president of the Republic of Ghana must do that, and he will declare that area. It can be a land or a building as a free zone. So maybe tomorrow the whole of Tema Port may be declared as a free zone, which means that customs duties and customs operations may not, or the law that relates to payment of duties and taxes may be relaxed or suspended. What that means is that that place is now a free port for purposes of taxation. And like we said in the earlier lecture, a free zone can be a port, it can be a river port, it can be a seaport, anywhere can be declared. And under section 7, we have noticed that even it doesn't require even a place, a land, an area of land. It can simply be a building. I understand that Nestle, they have an office around airport, and that airport is a free zone enclave. I'm not too sure, but that is what I heard. That building is a free zone. So that single building alone is a free zone, and therefore, if you operate from that place, you tend to get all the benefits and the benefits under the Free Zones Act regarding the exemption and the tax incentives. If you are going to Koforidua also, that area, there are some companies who are operating over there. They have a land, they have a farmland, and that farmland has also been declared as a free zone. When you are going, you see a signpost there, that indicates that it's a free zone area. So all of these places are declared as a free zone, and the president does that declaration on the recommendation of the board with free zone. So if you apply and you want to operate from any other place of your choice, and the free zone board identifies that there's no risks, and therefore you can operate from that area, then the declaration will be done. Subsection 2 says the declaration under subsection 1 of this section shall specify the area and the scope of activities in the free zone concerned. So when the area is declared as a free zone, then the nature of the activity that you need to undertake may also be declared or specified in the bulletin. Now let's look at section 8, which talks about the qualification of free zone developers. You need the thing is in stages. So if the whole of Tema, Titi Brothers area to Pombaria has been declared as a free zone, then we need somebody to go and develop the place, put a place in such a situation where people can just enter the place and start operating. So they are the free zone developers. They develop the area that has been declared as a free zone. The reason why we need a developer is that there are some restrictions. The fact that they are required to sell 70% of their produce outside Ghana is an indication that, look, if you are not careful, people will just go and get a license and then they will not be interested in selling or exporting the goods as we intended under the law, and then they'll be selling the goods in Ghana. So in most cases, you need some restrictions and some mechanisms in place to protect or to ensure compliance under the law. So let's look at developers. So it said no person shall develop, manage, or develop and manage a free zone unless it is a body corporate registered under the Companies Act. Companies Act now is no more Companies Code, so you need to put Companies Act 2019 Act 992, or a partnership registered under the Incorporated Partnership Act 1962 Act 152. As for the Partnership Act, it's not been repealed yet, but the Companies Code has been repealed, and now we have Act 992 2019. So we're saying that you can't be a developer if you are a sole proprietor. You need to be a registered company, or you need to come as a partnership. Now 2 says the body corporate or partnership shall be licensed to develop, manage, or develop and manage the free zone under this act. So if you want to just go into developing, putting in the amenities to ensure companies come there to operate, more like you are putting the place into a use, you can do that. If you want to also go into management of a place that has been developed already, that can also be given. Or license can be granted under the law. So each of these ones works for you. But what we need to understand is that there is a free zone developer and then there's a free zone enterprise. The developer is the one who is going to ensure that the place has been literally developed into a place that is conducive for operations as a free zone enterprise. Let's look at section 9, which talks about the rights and responsibilities of a free zone developer. When you are given the license to go into the development of an area that has been declared as a free zone, what is required of you? Subject to the Constitution, a free zone developer may, for the purpose of its activities, acquire land within the area declared in respect of it, and lease or sublease real property in its own name, has lease or has a right to use or sell or lease in, and may sell or rent buildings to free zone enterprises. So yours is to go there, put the place in good use, put in if there's a need to do a fence wall around the whole enclave, then you will do it. After that, then you can lease it or sublease it, or whichever way you want to do it. You can also acquire land, but like we have subjected it to the Constitution. Under the Constitution, there are some limitations regarding the acquisition of a land, especially if you are a non-Ghanaian, a non-citizen. The Constitution provides that you cannot get a lease for more than 50 years. So all of these things are put in place to ensure that, yes, non-citizens can acquire or can apply to be a developer, but then you have to pay attention to the limitations when it comes to the acquisition of land. 2 says it shall be the responsibility of a developer to construct and maintain buildings, warehouses, factory shells, and provide or contract other persons to provide utilities or services such as water, electric power, telecommunications, and sewage. Develop all other infrastructure necessary for the enhancement of the efficient and effective activities of the zone in accordance with any regulations made under this act. Provide fencing and enclosures to separate the zone from the National Customs Territory and ensure security of the zone. So from A to C, you have a responsibility. So for example, we're saying that you should be able to provide warehouses. You are in charge of that area, that enclave. You have applied to develop it. So if I come and I said I want to manufacture, there must be a place for me to do to warehouse my goods, because the whole intention under this act is you must export majority of your produce. So things like telecommunications, factories, and all those things, you must provide them, and that is the duty of a developer. If you look at C says provide fencing and enclosures to separate the free zone from the national customs territory. This is very important. The reason is that that area that has been declared as a free zone is not part of the customs territory. So you produce there and export, and it's seen as a place which is outside Ghana. So you need to protect that area. If you don't protect it and people produce, it's likely that they may bring it into the national market. And in the free zones, later we'll come and see that even when you are buying from a free zones, because that place has been considered as outside the territories of customs of Ghana, you are importing, literally you are importing from a free zone and enterprise into the national market. So that's why there's a need for you to enclose or provide fencing. This says provide and contribute to the cost of facilities for such on-site customs service as shall be determined by the customs division of the GRA. Again, we have customs exercise and preventive service. We're now talking about SEPS, but currently what is in place is the customs division of the GRA. So if the customs authority or customs division of GRA intends to do some more security measures or provide some facilities that will ensure that goods are not smuggled into the national market, then you have to also contribute to it. It says undertake any investment or financial venture to facilitate and promote the development of the zone, and submit within such periods as the board may direct reports on developments in the relevant zone to the board. So yes, the board will approve for you. You go and develop the place, fence it, and then you'll be in charge of anything that happens over there. Section 10 says subcontracting by developers. A licensed developer may undertake or subcontract the management, control, and promotion of a free zone development in the declared area. A developer shall apply for a license for any person to whom a subcontract has been given by it under subsection 1. The application for a license for subcontract shall be made to the board and shall be accompanied with a executed subcontract. So here we're just looking at a situation where the developer intends to subcontract something to another person to also perform some work over there. Great. So we've looked at how free zone developers can apply for a license, and we have established that it's only a company or a partnership. I don't know what you think about why we have taken sole proprietors out. Maybe begin to think about it so that when we meet and we are solving questions, we can look at some of those things. Why are sole proprietors taken out? We have some individuals who are very rich and therefore they can do the same work as developers are doing. Just consider why sole proprietors are taken out of the application for a free zone developer. Now we have the developer has put the place in place, well structured warehouses, factory shells, fence wall, nicely done. Now you want to go and apply to operate as a free zone enterprise. So what are the requirements? Let's look at section 11. Export free zone enterprises. It says that subject to the provisions of this act, any person may apply for a license to establish an enterprise in a free zone. So any person means that any person. Okay, any person. But section 12 brings out some qualification. So section 12 says that no person shall carry on a trade, business, or industry within a free zone unless it is registered under A, the Companies Act, or the Incorporated Partnership Act and is the holder of a license authorizing the carrying on of the trade, business, or industry under this act. 2 says a company or partnership qualified under subsection 1 and licensed under section 16 shall be referred to as a free zone enterprise. Again, look at how we have taken sole proprietors out. So you cannot operate in a free zone unless, 1, you are registered under the Companies Act, or you have formed a partnership and you have a license, you've been licensed under section 16 to do free zone operations. Nobody goes there unless you have a license. Now let's look at those who have been licensed to do free zone operations in the free zone area. Section 13, rights and responsibility of a free zone enterprise. A free zone enterprise shall have the right to produce any type of goods and services for export, but shall not produce any goods that are environmentally hazardous. So anything you want to produce, you have a right to do it, and you must do it for export. That is the initial intention. From the beginning of the act, we said that it is for economic development, and so the whole essence is produce and export so that we can also get some dollars in Ghana. Now we are saying that if you have a license, you have a right to produce anything at all. However, if the thing is environmentally hazardous, then you can't, the act does not permit you to do that. I don't know what amounts to environmentally hazardous, but I believe that the environmental specialists may tell us. Subsection 2 says a free zone enterprise shall be free to A, store, warehouse, pack, unpack, and repack, divide, subdivide, group, break down, assemble, disassemble, bottle, rebottle, can, recant, decant, alter, sample, display, grade, test, classify, mark, label, transfer, mount, refine, salvage, destroy, demolish, confect, process, and manufacture any foreign or domestic raw materials, intermediate, semi-finished, or finished goods or components for export or re-export. So these are your rights. You can do any of these ones as long as you have been licensed to go into that enclave or that building to operate as a free zone enterprise. Sometimes you can even bring finished goods from outside, and then all you just have to do is rebottle them. That is also permitted. So you can rebottle it if it is raw material, intermediate, semi-finished, or even finished good. Rebottle it to be your own, as long as you and the original producer do not have issues concerning patent and all those things. You can do anything at all. Most of the goods that we have in Ghana, I understand they are just repackaging in Ghana. Take Nido, for example. Nido, I understand, is meant for export, but at least some portions of their produce are made in Ghana. So you can bring raw materials from outside, repackage it in a free zone, and then export. That is also permitted. B says render and sell any type of information processing, computer-aided design, computer-aided printing and publishing, software development, telemarketing, and any other similar and related services. Can do all of these things. Render and sell financial, banking, insurance, commercial, advisory, repair and maintenance, professional training, and other services subject to all relevant laws and regulations for the time being in force, and carry out any other activities relevant to its license as may be considered necessary by the board. So it appears that almost everything from manufacturing to service provision can be done from the free zones enterprises, as long as the end destination is for exports. Now, section 14 talks about where you anticipate a change in your line of production. So assuming that you are licensed to produce Nido, and then this time you want to change your line of production to maybe milk or Milo itself or any other thing. Section 14 says that a free zone enterprise may change its production lines and processes as often as it's considered necessary, subject to prior approval of the board. So you need to go back to the free zone board and tell them that you gave me license to do this and I want to change it into this particular production unit. Great. Let's look at the licensing requirements for a free zone. And here it's more practical. You may have a client who wants to take advantage of the tax incentives within the free zones, and so you have to put in the application. Let's look at the licensing under section 15. Application for license to develop a free zone or operate an enterprise in a free zone. An application for a license to develop, manage, or establish an enterprise in a free zone shall be in writing. You have to apply in writing. Be submitted to the secretariat of the board, and then specify the zone to be developed or managed, or both, or the trade, business, or industry for which the license is acquired. And D, be accompanied with such information as the board may require. So you put in your application, tell us what you want to do. If you want to do you want to be a developer, or tell us the nature of business you want to go into, and you submit it to the board, and the board may require any other information. When you are called upon, you should produce it. 2 says the board shall cause response to be made to the application within 28 working days from the date of the receipt of the application. So when you put in your application and everything is set, they have to respond to you within 28 days. Section 16. Let's look at the grant of a license to a developer or an enterprise. The board may grant a license authorizing the development or management or both of a free zone, or the carrying on of a trade, business, or industry within the free zone. 2 says no license shall be granted for the carrying on of business of banking unless the applicant is also registered and licensed under the banking law. The business of insurance unless the applicant is also registered under the insurance law. And then a license issued under this section shall be under the signature of the chairperson of the board. Good. So the section 16 says that you'll be given a license to operate when you put in your application and everything is okay. However, if you are into banking, insurance, and all those things, because of the presence of the Bank of Ghana, you need a license to operate. You can't do banking without the Bank of Ghana licensing you. And you can also do insurance business without the National Insurance Commission licensing. So all these things, you need a license before you put in your application. And then you can come for the free zones license for you to enjoy the benefits under the Free Zones Act. Conditions of license, section 17. The board may attach to a license such conditions as it thinks appropriate concerning employment, skills development, impact on the environment, creation of job opportunities, and degree of export orientation. So all we're saying here is that, look, the board can attach some conditions to your license. For example, the number of people you should employ. Remember, the whole object of this free zone is development. So whilst you are exporting and bringing dollars, we also have to put in place how do you create jobs for the indigenes. So all of these things can be a condition that are attached to your license. The license can be revoked. Section 18. The board may revoke a license where it is satisfied that there has been a breach of condition attached to the license. The board may, upon the request of the licensee, vary at any time the conditions attached to the licensee. And before revoking a license, the board shall give not less than 14 working days notice of its intention to the licensee, and shall consider any representations made to it by the licensee. So the fact that you've been given a license does not mean that everything you are free to do. If the boards or if the law says that export so much of your produce, you have to comply. If you don't, the license can be revoked. But we give you 14 days notice, and then after the notice is given, you have a right to appear before the board to make a representation and let the board hear you. Let's look at the register. The Act requires that the board should put in place a register. It says that the board shall establish and maintain a register of licensees granted under Section 16 of this Act, and there shall be entered in the register in respect of each licensee the name of the person to whom the license is granted, and then zone to be developed or managed, or both, or the trade, business, or industry to which the license relates. And then 3 says that the register shall be kept by the board and shall be open for inspection by the public, subject to such fees as the board may determine. So the register is more like the list of people who are operating in the free zones. So, and it's available to the public, but you have to pay for a fee. The question is, can I transfer my license to another company? Section 20. No licensee shall transfer a license issued in respect of it to any other person without the prior approval of the board. So if I don't want to do the business again and a new person is coming, or even if I want to give it to another company, then I need a prior approval of the board before I can do that. Great. So those are the requirements. Now let's look at the most important aspect of this whole thing for exams purposes. Import and export. Import and export. Parts 5 of the Act. And like I mentioned, section 21 to 28 are very critical. You're going to need it for purposes of your exams. Now, let's look at section 21. Non-application of import laws to free zones. The laws for the time being in force relating to the importation and exportation of goods and services other than consumer goods for commercial purposes shall not apply to A. The bringing of goods directly from a country outside Ghana into a free zone. This is very important. So, we have a law that regulates the importation and exportation of goods and services into Ghana. Now, for purposes of a free zone, because we want to give you special treatment, we are saying that the laws are not applicable when it comes to a free zone import. If you are importing to any place that has been declared as a free zone, the bringing of goods directly from a country into Ghana, into a free zone, is not applicable. So when I'm bringing cars from UK to Ghana, if it gets to the port, if the destination is to a free zone enterprise, then the laws regarding custom duties and other things cannot apply to me, because the Act 504 says it is non-applicable. You can't apply it. So, and it's reasonable because we have already declared that place as a place which is outside the territories of Ghana. So Ghana Customs have nothing to do with it. They're not supposed, literally, they are not supposed to start enforcing their laws that go and send declaration, come and clear the blah blah blah. You may do it, but they may have some special rules. We need to amend the natural or the usual laws that we apply to any other person. And when the whole thing concerns a free zone, we use a special rule to deal with it. We'll come and look at how imports and exports are done when you are bringing it into a free zone enterprise. B says the dispatch of goods for export out of the free zone to a country outside Ghana, except insofar as such laws are made applicable by regulations made under this law. Yes. So if you are sending goods outside Ghana, yes, of course, we also leave you. That place you are exporting from is not part of Ghana anyway. But then there are some rules. People, if you don't control people and how they move goods, you tell you that I'm going to export it to Togo. By the time you realize the goods are in Ghana. So there are some regulations that are made to ensure that some of these things are not abused. Section 22, exemption from taxes of import into free zone area. It said that the import of a free zone developer, subcontractor, or enterprise into a free zone or single factory zone shall be exempt from direct and indirect taxes and duties. So this section says that anything that you are importing into a free zone, whether direct tax or indirect tax, whichever way it is, this is exempt. And this is where we are saying that free zones offers a very good and juicy tax incentives. All your imports, your raw materials, everything that you are bringing is exempt. The whole idea is that maybe you are coming to repackage them for re-export, or you are coming to manufacture something. So as long as you've been given a license to operate in a free zone area, all your imports and everything that you bring from outside into that free zone area is exempt from both direct and indirect tax. But section 23 is the most difficult part of the law that affect the free zone enterprises. The whole idea is that, look, they are supposed to export their goods, but then are you able to export 100% of your produce? It's not possible. So the law makes provision that at least part of their goods should be sold in Ghana. Let's look at Section 23(1). It says the minister may by legislative instrument authorize the sale of up to 30% of the annual production of goods and services of a free zone and single factory zone enterprise to the National Customs Secretary. So if you produce, we are saying that at least you can sell 30% of your produce to the local market. That means is that you can, or you are supposed to export at least 70% of your produce outside Ghana. It's only 30% you can sell in Ghana. Sales of goods from a free zone enterprise or single factory zones to the National Customs Secretary shall be considered as imports and shall be subject to the rules and regulations relating to imports into the National Customs Secretary. So if I'm going to buy from a company from TT Brothers in Tema, because they are free zones and I'm in Ghana, I'm going to buy it into my shop in Accra or anywhere. The law is that I am importing. Forget about the fact that it is in Ghana and therefore it is not at the port. It is an importation and therefore I need to pay duties. I need to pay everything that a person will pay as if it's being brought from outside Ghana. 3 says damaged or rejected goods or samples may be sold by the free zones and single factory and zones to the National Customs Secretary. And such goods shall be considered as part of the 30% of the annual production of the goods of the free zones and single zones authorized to be sold to the National Customs Secretary, and as such shall be subject to the applicable duties and taxes. Good. So even if you are giving samples to people in Ghana just to try, people outside the enclave to try, it is counted as part of your 30%, and if you go above it, it's supposed to be subjected to duties. An instrument issued under subsection 1 of this section shall provide penalties for contravention of any authority provided in it. Okay. 24. Sales from National Customs Secretary to free zones. This is also very important. It's also one of the tax incentives. So this time we have considered how a free zone sells to the local market. Now we are looking at how a local market sells to a free zone. So assuming they move from their enclave and decide to come and buy something, what does that mean? Section 24 says that sales of goods and services by a domestic enterprise from the National Customs Secretary to enterprises in the free zone and single factory zone shall be considered as export. So you are in Accra and you are selling to a free zone enterprise, you must consider that as an export, though they are just taking it to Tema, to their enclave. A domestic enterprise shall be eligible to benefit from the prevailing export incentives available to a national export and shall not require an export license for sale of any goods and services to enterprises in the free zone or single factory. So ordinarily, if you are exporting something, you need to go through the customs procedure. But we are saying that these guys are just in Tema here. So you have a right to sell to them and you don't need any license or any customs documents to be able to export. Though that place is literally outside customs territory and it is not part of Ghana. And if there is any benefit, any tax benefit or incentives from exporting, for example, if you export goods, the revenue or the profit that you get from the export, the tax rate is lower. If you export to a free zone enterprise, though in Tema, you must be entitled to the benefits that comes with an export. 3 says an enterprise in a free zone or single factory zone may purchase goods and services sold by a domestic enterprise with local currency obtained through conversion of foreign currency through the banks and any licensed foreign exchange bureau. Let's look at section 25, entry into free zone by officers. An authorized officer of any of the revenue services, member of the police force, or an officer authorized by the minister may, in the discharge of their official duties, at any time enter and inspect a free zone, buildings, aircraft, ships, boats, vehicles in a free zone. So for security reasons or any other reason, any of these officers mentioned above in performance of their duties can enter any free zones area. An officer exercising any power of entry or inspection shall, on request, produce his authorization. Any person who prevents or obstructs an entry authorized by subsection 1 of this section or attempts to do so commits an offense and is liable on summary conviction to a fine not exceeding $1,000 or its equivalent in cedis, or imprisonment for a term not exceeding 6 months or both. So when custom officers wants to come to that area to inspect, you are supposed to give access to the place to them for them to inspect. 26. Responsibility of Customs, Excise and Preventive Service. The Customs, Excise and Preventive Service shall be responsible for the control of zero-rated goods within a free zone. That is, if anytime you are selling outside the customs territory, the goods are supposed to be zero-rated. So the customs divisions are supposed to ensure it within the free zone in transit between two free zones. So anytime you're also selling between two free zones, it's also applicable. You are exporting and therefore there's no tax in there. In transit between a free zone and a point of entry into or exit of Ghana, out of Ghana. The minister, after consultation with the minister responsible for customs and excise and the commissioner of customs, excise and preventive service, may by legislative instrument make regulations adopting or modifying for the purpose of this act any of the regulations relating to customs operations, governing the movement of persons, vehicles, or goods into and out of a free zone from and out to other parts of the customs territory, covering the keeping, storage, and handling of goods in a free zone, covering the keeping and preserving of accounts and records in a specified form in respect of goods in the free zones, and relating to the provisions of security by bond or otherwise on goods in transit between free zones and points of entry and exit from and to other countries. So there's a regulations. I'll share the regulation so that we'll go through it. The regulation deals with some of this. Section 27, then we'll break to other continuing with the next video. Section 27 talks about where goods are missing. You are producing but it's missing, and therefore if it's missing, is it that it's been smuggled or it's been stolen into the authorities of Ghana? You remember you have just 30% seal into the local market, 70% must go. Where goods stored in a free zone are found to be missing without an acceptable explanation, the commissioner may request the licensee to pay the duty on the goods at the rate in force at the time, in addition to any penalty which may be imposed by the commissioner. Yes, so we don't want them to steal the goods and come and sell it in the local market. That's why we've even required that developers must fence the place. Now, if the goods are missing, then you have to pay for the duties and taxes that are there, and then it's a breach of the law, and therefore you must pay some penalties. So break here and then come again for the last part of this law on the free zones. So see you in the next video.